Let's be real. When people hear offshore trust or hybrid trust, bridge trust, they usually have one or two reactions. Either they think some shady tax dodge thing is going on, which it's not, it's tax neutral, or they assume it's just something for billionaires. And let me guess, you've heard about offshore trust, maybe even the bridge trust. You've done a little bit of research, which is great, and that's probably why you're listening right now. And you're wondering, is this even legal? Is it some kind of loophole? Can someone really stop a lawsuit with a trust? And I get it. There's a lot of noise out there, a lot of conflicting information and methods and misconceptions. So in this video, I'm going to break it all down in plain English. Just what is the bridge trust, how it all works, and more importantly, the geeky side, what IRS and Treasury rules and regulations apply. Like this is how we know like why it's 100% legal, court tested, and used to protect billions in assets over the last 30 years. So what is the bridge trust? The bridge trust is a hybrid asset protection trust. It combines the offshore protection of a Cook Islands trust with the tax simplicity and usability of a domestic US trust. So think of it like a hybrid car combining the best of both worlds. Or you can think of it like having two passports. While your trust is domestic, it's easy to use and tax simple. Its US passport is its IRS compliance. But when you're under legal threat, like a lawsuit, it has the power to bridge offshore into the Cook Islands, putting your assets outside of the US court jurisdiction. And its offshore passport is its registration with the Cook Islands from the very first day that it's created. So a natural question comes up is just why not just start with the Cook Islands trust if that's where we're going to end up? A purely offshore trust like the Cook Islands, like they are powerful. They are literally the most powerful trust in the world by far. Nobody even disputes that. But it's generally not something that we start out with 99% of society because they're not always practical to use for most situations. First, if they're done right, they're expensive. They require full IRS disclosures like 3420s, 3520As, and FACTA disclosures, and sometimes even full trust disclosures. And they force you to give up control from day one. And most people just aren't comfortable with any of that. And that's why we built the bridge trust to give you a domestic control and tax simplicity now, which then gives you offshore strength later when it's needed. So what's the legal foundation and statutory authority? Essentially, just is the bridge trust legit? Yes, absolutely, because it's built directly on US statutory law and Cook Island legal principles. So let's start with the US side. And for the next few minutes, this is where I'm going to get kind of geeky on this part of it. The bridge trust qualifies as a grantor trust under IRS sections 671 through 677, which means for tax purposes, the trust is ignored and everything flows through to you personally tax-wise. And here's what matters. 671 means you're treated as the owner of the trust assets. 673 applies if you keep a reversionary interest. 674 lets you control income distributions. 675 applies if you retain control over investments. 676 makes any revocable trust automatically a grantor trust. 677 covers trust where income can be distributed to a grantor or used for their obligations. That's the tax foundations, but it gets better. Under Treasury Regulations Section 301.6109-4B2, a grantor trust doesn't even need its own tax ID number. So as long as the trustee, which is you, uses your social security number, we're good to go. And under Treasury Regulations Section 1.671-4B2, there's no separate tax return required for a grantor trust that are owned by a single person, as long as all the income and its deductions are reported on your personal tax return, which they're going to be. So essentially, they are disregarded up to you. So what does all this mean? Full IRS compliance, zero extra tax filings, completely legal. So what's the bridge part mean? So here's the power move. The bridge trust stays domestic until a legal threat arises, like a lawsuit. Then it bridges offshore into the Cook Islands when it's necessary. And if you're wondering whether that offshore element actually works, here's the record. In over 30 years, more than 300 legal challenges have been brought against our clients, and not a single one has ever followed us down to the Cook Islands, and the trust has upheld every single time. And the Cook Islands, well, in 40 years, in every single case, no U.S. creditor has ever successfully forced an extraction of Cook Islands trust funds. Not one. Even when the trust was drafted poorly, like in the Anderson famous case, or the U.S. versus Grant case, or the SEC versus Solo case. What happens is when a person suing you comes after you down the Cook Islands, they're either going to give up or they're going to settle for pennies on the dollar. This even applies for super creditors like the government, the SEC, the IRS, like the man who's coming after you. So then, why the hang up? A lot of law firms don't focus on high-risk net worth individuals. It's not their client profile. They get more clients by casting a larger net to middle America. So there's no need for them to learn this level of protection. So those clients that don't get service, they generally get referred to firms like ours. And some people get hung up on this. Where's the case law on specifically the bridge trust? Here's the answer. In the legal world, statutes define rules. That's where legality comes from, not case law. Case law gets created when judges have to interpret statutes that are not clear. The bridge trust is built on clear statutes, IRS sections 671 to 677, and the regulations I mentioned before. Again, case law only comes into play when statutes are unclear or violated. But when you're 100% compliant from day one, there's nothing to litigate. There's no clarity of law for a judge to make a ruling on. And when rulings are made, they only get published to clear up an area of law that was unclear. And that's why the bridge trust has over 300 successful outcomes, all resolved favorably through settlements, not courtroom battles. So then why is it that CPAs and lawyers don't get this or know about it? Asset protection isn't taught in law school or CPA school. It's not on the bar exam. Most law firms do not practice this area of law. CPAs look at tax mitigation strategies, not law strategies to help you, avoid lawsuits or prevent paying judgments. And estate lawyers only understand revocable or irrevocable, or just basic LLCs. There's a gap of knowledge. Asset protection, and specifically offshore asset protection and hybrid trust, is a very nuanced area of law. At times, confusion comes up with accountants and attorneys who are unfamiliar with trust and combining irrevocability with grantor status, but that's understandable. It's just not their area. But asset protection is a specialty, just like brain surgery and heart surgery. Not all doctors are the same, and you also have general family doctors, right? They're not going to be operating on your brain or your heart. The bridge trust isn't just clever, it's statutory, it's court tested, and it's battle proven. So what are some frequently asked questions? One, is the bridge trust legit? Absolutely, we just went over that. It's based on the IRS codes, Treasury regulations, and Cook Islands law, and it's worked in hundreds of real-world cases. Second one, will I lose control over my assets? No, you won't. Will the trust is going to be domestic. You'll retain full control. It's what's called self-settled, meaning it's created for you, by you, as your own beneficiary. If it's bridges offshore, the offshore trustee at that point in time steps in, but only per your instructions in the trust and only when it's needed, like during the actual time of the lawsuit. Third, do I have to file extra tax returns? No. Thanks to IRS section 671 and 677 and the Treasury regulations 1.671-4B2 and 301.6109-4B2, everything is filed under your social security number, meaning no extra tax burdens at all. It's actually very simple. It cleans you up from a tax perspective. To summarize all this up, is the bridge trust for everybody? No, it's not. Just be simple about that. If you have $1 million or more in exposed assets in a high-risk profession like a doctor, real estate investor, dentist, CPA, if you're serious about protecting your assets from lawsuits, future liabilities, or just uncertainty, then absolutely, this is your tool. The bridge trust gives you U.S. tax simplicity, offshore legal strength, and a 30-year record of doing exactly what it was designed to do. Keep your wealth safe. This isn't theory, it's backed by law, backed by statutes, and backed by real-world results. If you want to learn more, click the link to book your legal consultation strategy with me. I'm Brian Bradley. Thanks for watching, and remember, all it takes is one lawsuit to lose everything you worked so hard for, and it's too late to protect your assets once the lawsuit is actually filed. So the key is to plan now, not after.